Hello everyone, welcome to Management 413 Employment Law here at the UAB Collat School of Business. In this video we will be covering performance appraisals, training, and development using Chapter 16 of our textbook, Employment Law for the Human Resource Practice. Here is our chapter outline. We will be looking at the performance appraisal process, and we will also be looking at training and development, primarily with an eye toward ensuring that there is no discrimination that might be occurring, illegal discrimination that might be occurring in the operation of those processes. Performance appraisals are a big part of a manager's job, including a human resource manager's job. There is no universal agreement about how well they work, but they are almost always going to be used. The central concern is that they not be discriminatory. You have to appraise women just as often as you appraise men, and all protected classes have to be appraised in the same process, using the same process. In general, there is no duty to conduct an appraisal, but almost all organizations do. Many times after a negative performance appraisal is received, the recipient will say, "I've been discriminated against." A negative performance appraisal is not discrimination. It might be if it were biased because of some illegal discrimination, illegal treatment going on. But let's look at a few examples of where that might occur in a minute. Performance appraisals can affect many other parts of the employment relationship, including promotion and raises, and therefore we need to be very careful in how we handle those. Courts will not step in and second guess the contents, the results of a performance appraisal. They will only look at them in order to figure out if there was some discriminatory intent. It is extremely important that if there are problems, that you have a performance appraisal and write them down, as awkward and as uncomfortable as that might be. I have on many occasions found that there were performance problems that could not be documented and used to take a step in employment process, such as a salary decision or maybe even a termination, because the prior negative performance appraisals weren't written down. Therefore, the employer could say and the employee could say they never happened. Here are some common performance criteria to use in appraisals. Employers are generally free to establish their own criteria, whatever they might be. They obviously should be related to objective job performance. If there are any disabled employees, you should be sensitive to what those standards might be, not to disadvantage them right out of the gate. They should be consistently applied, as objective, as observable as possible, and of course they should be job related. If an employer does not have a professional, well thought out set of criteria for job performance, it can result in a claim by an employee that the employer was negligent in how they handled job appraisals, and that can result in liability. That was what was at issue in Chapter 16's Question 2 simulation that a pair of you will get. An employee who had just received a bonus and had even received an all expenses paid trip to Hawaii was fired after an appraisal in which it was said that she was, quote, not a good fit. It doesn't sound like a very objective standard to me. Disabled employees should be held to the same standards. If there is an accommodation, however, that should not be held against them. And likewise, if a disabled employee is not able to perform a marginal function of a job, a non-essential function within a job, that should not go into and create a negative appraisal where otherwise there would be a positive appraisal overall. Not being consistent in evaluations can create problems. If, for example, a negative evaluation occurs for the first time after an employee has filed some sort of complaint, maybe a charge of discrimination, that can appear to be retaliation. The moral of the story is, again, if you have negative things to say about an employee, say them, write them down, because if the first time you say them is after some event has occurred, it would be inconsistent and it could give rise to legal problems. It could give rise, for example, to an argument that the appraisal was just a pretext for what was really illegal discrimination. Look at the case in your book, Rochelle versus Singular Wireless, where a poor review was found to be a pretext for racial discrimination because the employee had had several years of very good reviews. Sometimes there are appraisals done by peers. Most times appraisals are done by superiors, but whoever does the appraisals, whether peers or superiors, should be well trained in the appraisal process. Look at the example of a case on page 598 of your textbook where a pilot was given poor peer reviews after crossing a picket line, and the question was whether those poor peer reviews were as a result of the employee, the pilot, engaging in protected concerted activity, or were they really because he or she was not a good airplane pilot? The contents of appraisals can sometimes be difficult, can be awkward to say negative things about someone. An appraiser should not shy away from criticism, but by the same token, there should be no thoughtless stereotyping like the appraisals that we saw earlier in the semester, where a department chair at Ohio State University had comments like this written down about these particular professors at Ohio State, that they were used pretty easily to show illegal discrimination based on age. Sometimes companies can engage in a performance process, a performance method, where they stack rank employees. Somebody's got to be 1 and somebody's got to be 10. Forced rankings are controversial. They're not necessarily illegal. However, unless they are really an attempt to illegally discriminate, they are really a disparate treatment according to a protected class or have a disparate impact on a protected class. Appraisals should not be kept a secret. They should be communicated. They should be the subject of discussion. And most importantly, they should be written down. If they are not written down, it's as though they didn't occur, and the employee is likely to attempt to rewrite history if you have only orally communicated the negative appraisal. They'll say, I don't remember anything negative, and if it wasn't written down that it was negative, the trier of fact, be it a jury or the grievance panel, whoever it is, might well agree with the employee. Many times a negative performance appraisal can lead to what's called an improvement plan, sometimes a performance improvement plan, a PIP. Those are fine, but occasionally they can lead to problems. For example, in this case involving Walmart, a longtime employee, was put on a performance plan after years of progressively rising in the organization, and he was told that he couldn't rise any further because he was on a performance improvement plan. And in fact, there was no such policy, and the court held that a reasonable jury could say that really the reason was not the performance improvement plan that he couldn't be promoted any further, it was because of his age. Let's move now to training and development. These can be very important. It can be very helpful to help people move through the ranks, including women and others who are subject to the glass ceiling that we have talked about. There can be problems if you are inconsistent in who gets to go to training and who pays for it. In general, employers have no obligation to train their employees. A very important exception to that would be, as we saw before, if you are in a hazardous industry of some kind, you might, under OSHA standards, be required to train for safety and health reasons. That's what was found in this particular case that you can find in your textbook, Compass Environmental, where a construction company was found to have failed to train a new employee who had been electrocuted on the job, and the finding of the case was that the company was liable for the failure to train. OSHA has a standard that when there is a hazard that the employee has a right to know about that. Chemical manufacturers in particular have some very strenuous training requirements. Here's another training requirement. The Drug-Free Workplace Act that we've mentioned earlier in the course actually requires a form of training. If you are a federal contractor, you must train your employees. The training can take place simply by telling them that there is a policy, but the training is designed to make sure that the workplace is drug-free. Sometimes discrimination might be charged on the basis of who is selected for a training program, because the only people who will get promoted are those who have gone through the training. You should be very careful in making sure that your training is available to everyone, including people in protected classes. Here's an example of a person who was disabled because she was born with only one hand, and she successfully sued a school system for not allowing her to go through training with others. She said it was on the grounds that she was disabled. That is it for this set of slides. In the second half of this learning module, we will be looking at Chapter 17, Privacy on the Job.